There is a motion at the desk. The Chief Clerk will report the motion.
NISCA moves that Senate File number 3210 be taken from the table.
I recognize the member from Anoka, Representative Niska.
Thank you, Mr. Speaker. That is my motion.
All those in favor of the motion to take Senate File 3210 from the table signify by saying aye. Aye. Any opposed say nay. The motion prevails. The Chief Clerk will report the bill.
Senate File number 3210, an act relating to human rights, including disability accommodations as protection from discrimination.
I recognize the author of the bill, the member from Olmsted, Representative Hicks.
Thank you so much, Speaker, and thank you everyone for hearing this bill today. I know we got a little bit of a preview yesterday, but I will just go through a little bit about what this bill does. This bill really sends a message to people with disabilities and to establishments across this state that it is not okay to discriminate against people with disabilities. It is not lawful to discriminate against people with disabilities, and that they must engage in a process to identify reasonable accommodations. And so with that, I believe we have an agreement on an amendment.
There is an amendment at the desk. The Chief Clerk will report the amendment.
Nadeau moves to amend Senate File number 3210, the first engrossment. The amendment is coded RA 26-029.
I recognize the member from Hennepin, Representative Nadeau.
Thank you, Mr. Speaker, and thank you, members, and thank you, Representative Hicks, for bringing this and working with us on it, to keep this moving forward. This is, some people might think that this is not that important. Other people think it's, really important. And I happen to be one that thinks it's important to keep this discussion moving forward. And what the amendment does, members, is it adds, there's a couple of words, reasonable. So a reasonable accommodation, which mirrors the federal language for accommodations that are made for any and all people living with disabilities. And then it also, on page 2, line 7, it basically adds a statutory reference that Minnesota has for disabilities. That's the amendment, and I would recommend a green vote on this bill, members, or this amendment.
Further discussion on the amendment. I recognize a member from Olmsted, Representative Hicks.
Yes, that is the amendment, and we have reached an agreement that clarifies reasonable, which is already in law, and ensures that it's very clear who a person with a disability is. Please vote green.
Any further discussion on the amendment? Seeing none, all those in favor of the amendment, please signify by saying aye. Aye. Any opposed say nay. The motion prevails. The amendment is adopted. There are no further amendments at the desk. The Chief Clerk will give the bill its third reading.
Third reading, Senate File number 3210 as amended.
Third reading. Discussion. I recognize a member from Anoka, Representative Niska.
Thank you, Mr. Speaker, and Representative Hicks. I agree with the message that we're trying to send. I'm sad to say I don't think that this bill still is good legislating and good legislation. So I do have a few questions for Representative Hicks so we can try to understand exactly what the bill does and doesn't do, if Representative Hicks will yield to a question.
She will yield, Representative Niska.
Thank you, Mr. Speaker. And Representative Hicks, the process that is referenced in your bill, how does one in employment understand what the process is that is referenced in the bill?
Thank you so much for the question.
Representative Hicks.
Oh, I'm sorry. The process that is detailed in this bill, specifically on line 2.6, is the same, affirms the public policy and is not creating new or different process in any area of law, employment, housing, or public accommodations. The process that's detailed in 363A.08 and well-established case law is the process that's required for employment. The purpose of this bill in front of us today is that public policy for the state to secure persons in this state freedom from disability discrimination in all places.
Representative Niska.
Thank you, Mr. Speaker and Representative Hicks. I appreciate that answer, especially as it relates to 363.08 in the employment context. What about in 363A.10, if Representative Hicks will continue to yield? How does the bill affect the meaning of that provision?
She will yield. Representative Hicks.
I'm sorry, Representative Niska. Can you give me the statute one more time? I didn't write it down fast enough.
Representative Niska.
Thank you, Mr. Speaker and Representative Hicks. I'm asking about 363.10, entitled Real Property Disability Discrimination, which defines what reasonable modification or accommodations would be in the area of housing and real property.
Representative Hicks.
Thank you so much, Speaker, and thank you, Representative Niska. So I'm looking at subdivision 4, and I see what you are referencing, and I would just reiterate again that this bill, these 39 words, actually, I think now with the addition of Representative Nadeau's amendment, we're up to like 56 words. But these 56 words would just require that when there are conversations around reasonable accommodations related to anything in this chapter, that a good faith effort to have that conversation needs to occur, or it may be considered discriminatory. So we're not touching this statute of law. It's still there.
Representative Niska.
Thank you, Mr. Speaker and Representative Hicks. Appreciate that answer. With respect to 363A.11, does your bill change the meaning of that provision? That's the provision that discusses discrimination in the area of public accommodations. Are any of the specific prohibitions in that changed by the meaning of your bill?
She will continue to yield. Representative Hicks.
Thank you. Again, this bill is in the public policy section and requires that individuals engage in an accommodations process in good faith, and if they do not, it may be considered discriminatory.
Representative Niska.
Thank you, Mr. Speaker and Representative Hicks. You gave a more clear answer with respect to the other provisions than you did with respect to point 11. Does your bill, if it's adopted as amended, change the meaning of any process required under 363A.11, if Representative Hicks will yield?
She will yield. Representative Hicks.
Thank you so much. And again, thank you, Representative Niska. I would just like to reiterate that this is in the beginning of this chapter of law around public policy, and it says that if an entity does not engage in a reasonable accommodation per Representative Nadeau's bill, that it may be considered discriminatory. The chapters of law that we are apparently going through point by point are impacted in the broader sense that reasonable accommodations will need to be a part of that conversation, and if it is not, then it may be considered discriminatory. And we can, I have the whole chapter of law. We can go through every subdivision if you want to, but I frankly do not understand. The answer is the same for each subdivision because we are not touching those subdivisions separately. Additionally, I want to reground us back to this is about discrimination against people with disabilities. This is now with Representative Nadeau's amendment, 57 words, I think. I'd have to double count that. Maybe Representative Nadeau can count it for me. We were at 39 before your additions. It is now a handful of words in law that say that all entities must engage in that process. And individuals with disabilities have asked us to do this. Individuals with disabilities are here today. Individuals with disabilities and the Disability Law Center have all testified. And we have worked in good faith to come up with an amendment that ensures that it's reasonable and ensures that it is specific to disabilities. And so I would respectfully request that we get to the heart of this issue and not go line by line through this chapter because the answer is not going to change.
Representative Niska.
Thank you, Mr. Speaker and Representative Hicks. I think we are getting to the heart of what your bill does. And in particular, I'm concerned that you're not willing to answer a question about 363A.11, which is about the public accommodations discrimination. That's an area that we have in particular in Minnesota had very serious litigation problems about, that we've had a series of very serious problems with shakedown litigation. We talked about, I mentioned this yesterday, that this body had to amend the Minnesotans with Disabilities provision to deal with public accommodation discrimination problems. And so with respect to 363A.11, I'm particularly concerned that you're not offering me the same answer you had offered before. We have in your bill as amended, again, getting to the heart of what your bill says, it references a process to determine, I believe, whether if a reasonable accommodation is now the amended language, and it references public accommodation. So every store, every bowling alley, anyone who opens their business to the public now has to be willing to engage in a process for public accommodation. And so I'm just trying to understand, what is the process that someone who owns such a business, a public accommodation, what is the process that person is supposed to go through if your bill passes into law? What is the process that's referenced in line 2.6, and how does one understand what that process is if Representative Hicks will yield?
She will yield. Representative Hicks.
Thank you so much. And just to clarify for the record, I do believe I answered the question, but I'll try one more time. This is in the public policy section and requires entities to engage in a conversation about reasonable accommodations. So the part of the bill that you are, or the part of the Human Rights Act that you are referencing, 363A.11, that already talks about disability discrimination, that we did modify because there was some concerns, will still remain as strong as it was prior to this. And now we've added in public policy. And thank you to Representative Nadeau, we've added the word reasonable. So I think when we put all of those pieces together, what we have in front of us is an opportunity to show people with disabilities in this state that they cannot and will not be discriminated against. And when they work in good faith with individuals who own public accommodations to find a reasonable accommodation, that will be protected in law. And so if that does not occur, there will be an opportunity to make sure that folks are not discriminated against. So I think I've answered it now. I'm happy to discuss that further if I'm incorrect, but I think I have answered that.
Representative Niska.
Thank you, Representative Hicks. I think you said that it doesn't change the meaning of point 11. I hope that's the answer to it. If we are amending point 11, I think as a legislature we should be forthright about that and actually amend the language of point 11. Same question with respect to 363A.12 regarding public services. Your bill references public services. Is 363A.12 changed in any way, the meaning of 363A.12 changed in any way by your bill, if Representative Hicks will yield?
She will yield. Representative Hicks.
Thank you so much, Speaker. Thank you, Representative Niska. As previously stated, this 57 words is in the public policy portion of this bill and relates to the chapter of law to ensure that reasonable accommodation conversation occurs in all areas of life for people with disabilities. That will include 36.A12. It will include 36.A13. I mean, like, are we going to go through page by page? Because the answer does not change, because this, and I'm not a lawyer, but I did write a lot of statute in previous roles. And so when the first part of a statute that directs how the rest of the chapter of law is applied is amended, all of the parts of the chapter of law following that are part of that conversation. So that's what I've done. And so the answer is the same. It would require that the entities described in 363.12 engage in a conversation about reasonable accommodations for people with disabilities.
Representative Niska.
Thank you, Mr. Speaker, and thank you, Representative Hicks, for that answer. I guess I am disappointed to hear that it seems to be changing. It should have been a pretty simple yes or no question that we are amending or we're not amending different portions of, or changing the meaning of different provisions. It sounded like you said with respect to employment that we're not changing the meaning of that provision. With respect to this, you said when we change something in the public policy provision of the statute, all of the parts are part of that conversation. I think that means that all of the parts of the Minnesota Human Rights Act with respect to disability discrimination now have a changed meaning, and we don't have clarity about what that changed meaning is. We don't have clarity about what the process is that will be required in each one of those particular areas. We have clarity in our statutes in 363A.08 about what the process is that is required with respect to employment. I think if we want to take portions of that process and put it into other places in the statute, we should be forthright with the people of Minnesota, with the public accommodations of Minnesota, with the educational institutions of Minnesota, with the disabled community of Minnesota about exactly what that process is and is not. The concern that I have is that all we're doing really in this bill is inviting lawyers to make arguments in court cases about what a process would be, and that's going to create a lot of potential problems. It's going to create a lot of potential problems in the area of education. Our educational institutions are not going to know exactly what the process is that is required unless and until they have a case brought against them. That case is litigated. If they can afford to litigate that case to a verdict, a district court judge will then tell them about whether or not that process they followed applies. Then they will have to go eventually up to the Minnesota Supreme Court. Perhaps the Minnesota Supreme Court will provide some clarity about what that process is. Is that process in other contexts the same as 363.08, or is it not? Is it somehow different? Again, we should be saying that as legislators. We did that job when we amended 363.08, when there was a question about whether the interactive process applied in the employment context or not. That's our job as a legislative branch, to look at that process language, to amend, to offer specific prescriptions to people, clarity to people, and write that into the statutes. What we have here instead is a backdoor effort to change the meaning of some of those provisions through the public policy section, through inviting lawyers to bring cases, to litigate those cases. Members, this bill, I appreciate Representative Nadeau's efforts to make this better. He did make this a little tiny bit better. It is still far from ready. It is still far from the work that we need to do, not just for those who, businesses or schools or other folks who might be affected, but for the very disabled folks that we're trying to help and protect. Inviting people to make lawsuits, inviting people to get involved in litigation does not help anybody other than lawyers, other than judges who now have more power. Lawyers have more opportunity, more work to do. The bill before us today simply isn't the solution to the problem. It frankly creates potential ambiguity, I think, as regards to employment that weakens the protections for disabled people, and in other areas is just abdicating our legislative responsibility to the judicial branch. So members, I'll be a no.
I recognize the member from Clay, Representative Joy.
Thank you, Mr. Speaker. Will Representative Hicks yield for a question?
She will yield. Representative Joy.
Representative Hicks, since I own a gas station, what process will I have to change if this becomes law to enact in my gas station?
Representative Hicks.
Thank you, Speaker. You will have to have a conversation about individuals who are requesting reasonable accommodations. So I would assume that you already probably do this because we've served together and I've seen you in human services, and so I know you have a heart for people. So if someone comes to your gas station and can't get out of their car, right, I assume that you probably have a little sign on your gas pump that tells them they can call and someone will help them. And maybe if you don't, that is the process that you should engage in, right? It's to meet that need. And I believe that most Minnesotans and most business owners, you probably do want to do that. You probably already do that, right? And so if there's a reasonable accommodation that you need to provide, you'd have a conversation with someone about, hey, how can I help you here, right? And if they say, could someone help me pump my gas? I can't imagine you'd say no, right? So that's it. It's that simple. It is, by the way, we did count. It is 46 words. So that's all. It is being a decent human. It's making sure people with disabilities are able to have a conversation to make sure they can participate fully in our community. That's it.
Representative Joy.
Thank you, Mr. Speaker. I didn't really get clarification, but I do accommodate things at my store like this. But this just seems like it's opened me up for litigation. It doesn't answer like this is going to be more money to my attorney for retainers, just trying to figure out the process of this, of how this is all going to work. We're taking care of our customers now. We're doing what we need to do now. I have people with disabilities that work for me right now. And so to me, the question is you're going to have to put stickers on your pumps. You're going to have to accommodate for this. Now it's going to be a law that's going to be opened up that I could end up in litigation, more expense on a business, which raises the cost. As we continue hearing about mandates and what's going through, this is concerns I have as a business owner right now in Minnesota. And we continue to add these, and we're wondering why costs are going up and why we continue to do this. It's because of these unknown questions we have. Does the cooler door open wide enough? Are the shelves wide enough? Where's it gonna end? I mean, we have a lot of things coming through, but there's no real process here that spells it out. It's just gonna be, like we've heard many times, the lawyers taking my money and litigating this, and I'm gonna have to defend myself. I mean, this to me is just another mandate to businesses. And I think this needs a lot of work before we move forward because the answer is not here. I just can't put my finger on it right now when I look at this, what's moving through the House today. And I appreciate the passion, I do, and I understand that. And us as employers, we welcome everybody. We have people that pull up that can't pump their own gas. Minnesota used to not allow you to pump your gas, now they do. But we accommodate for that. I don't need St. Paul, Minnesota telling me to do that. I don't need a process put in play that lawyers can go play politics over and come after businesses on this. We do not need that. I think this bill's moving too fast. I think it should slow down, but that's, I guess, Mr. Speaker, thank you.
I recognize the member from Ramsey, Representative Finke.
Thank you, Mr. Speaker and members. I just wanted to let the representative know that accommodating people with disabilities is not a mandate from St. Paul. It is the federal law. It is state law. We are not asking people to do something that is either unreasonable or not already in the law. You have to accommodate your employees. And the problem with saying what is the process, let's put the process into law, is that every individual with disabilities will require a unique experience in that process because everybody doesn't need the same accommodations and every human person doesn't interact the same way with requesting accommodations in the world. So I think the little game about let's explain exactly what the process is when it comes to requesting disability accommodations, in Minnesota, but just anywhere in this country, is that process is a nightmare. We are trying to make sure that the power dynamic and the power differential is recognized because people need accommodations and usually they are denied. Just usually they're denied. Every person has a unique need for their accommodations. The process is you engaging in a good faith way, whether you own a gas station or any other business. There is no what about my version of business when it comes to not accommodating people with disabilities. It's a good bill. Thank you, Representative Hicks. Thank you to everyone whoever worked in the backroom negotiations to avoid the Human Rights Act wormhole. I'm very grateful to you. I think that we are passing some good law here, and we should all vote green.
I recognize a member from Ramsey, Representative Lugar-Nicolai.
Thank you, Mr. Speaker, and I rise in support of this bill. This is a good bill. It remains a good bill. It was a good bill yesterday. It is an even better bill with the help of Representative Nadeau. Good job. Some of the comments that I have heard today have concerned me. As an attorney, I feel attacked personally, professionally, in every way imaginable. It's hard, and I hope that everybody takes pity on me. But actually, I will say in all seriousness, oftentimes when I hear hostility to the work of plaintiffs' attorneys, individuals who are really helping other people navigate their rights in a system that isn't always helpful to them, rights that exist because we weren't respecting them previously, I hear hostility to those people being helped, not to the lawyers. I'm overhead, folks. I won't get a cut. Doesn't matter. I'll be working with people irrespective of whether or not this law passes, and I will not get 33%. Some of my friends will. But the work that they do is important because it helps people navigate rights that they may not be able to navigate on their own, much like people who are mechanics help me navigate my car. It is work that is important because it underscores the importance of the laws that we pass and the supports that we create for individuals who otherwise wouldn't have access. This law helps to reinforce existing law, which requires accommodations in public access, at the gas station, at the movie theater, in schools, in hospitals, in employment. And these laws all state that access, including for disabled persons, that it must occur. I'm just looking at point 12, 363A.12, which we were previously speaking about, fail to ensure physical and program access for disabled persons. What this law requires is a conversation. The interactive process is not rocket science. It is not integral calculus. It is not anything particularly difficult. It is one person standing up and saying, I have trouble accessing this service, this job, this educational facility. Can you help me? Sometimes the employer says, is that accurate? Do you actually have trouble? Do you have a physical limitation, or is there anything really wrong here? So then the conversation proceeds to some sharing of information. And then at the end, either there is an accommodation because it is possible, or at times, sometimes the employer says, or the place of accommodation says, I can't do this. It's an undue hardship. That's also built into our law already. This reinforces the work and helps to provide support to the Minnesota Department of Human Rights in performing that work. But these things exist in statute. They are important. They exist for a reason, and this process will not be particularly obscure or difficult for any person who is willing to participate in capitalism to navigate. You do way harder things on a daily basis. So I strongly urge a green vote on this.
I recognize the member from Sibley, Representative Harder.
Thank you, Mr. Speaker and members. This has been an interesting conversation, and I'm just trying to understand what are we trying to solve with this bill. For many years, I worked with individuals who were disabled. They could have been blind, in a wheelchair, developmentally disabled. I worked, it was called a job coach, which means I worked with people in a business, working to make accommodations. I worked with people in a workshop at home, and we always made accommodations for people that were disabled. And so I'm just speaking from experience, from working with those that are disabled. I'm just wondering what are we lacking that we aren't doing now that's already in law. So I'm having a hard time to support this bill today because having, like I said, worked in the field, and we always try to do reasonable accommodations for everyone that came through the door that we worked with. So thank you, Mr. Speaker.
I recognize the member from Ramsey, Representative Feist.
Thank you, Mr. Speaker. I just wanted to rise as one of the people on my side of the aisle who is an employer. I have been an employer for almost 16 years now because I am old somehow. But I am really grateful to Representative Hicks for bringing this bill. Over the time that I have employed people, we have provided accommodations, and that has enabled my team to be benefited from just a diversity of talent over the years, and I'm really grateful. So, you know, when we as employers do right by our employees, that comes to benefit us and nobody sues us, and all of those things are good. So I just wanted to rise to say that, as an employer in the state of Minnesota, I think this is great and important protections, and I thank you, Representative Hicks. Thanks.
I recognize a member from Anoka, Representative Niska.
Thank you, Mr. Speaker, and members, thank you for the discussion. One of two things has to be true. Either this bill does nothing, in which case we're just kind of doing some vibes here, messaging. I appreciate the message. I do agree with the message. Or it does something. And the concern that I have, especially given Representative Lugar-Nicolai's speech today, is that I'm not sure that we're getting a very clear answer about whether it does nothing or does something. Representative Lugar-Nicolai yesterday said that we should calendar this bill so that we would establish a process in the other portions of the Minnesota Human Rights Act other than .08, because .08 is the only one that sets out an interactive process. And today, she just said that these things already exist in statute, and so there's nothing really to worry about. So, Mr. Speaker, if Representative Lugar-Nicolai would yield for a question.
She'll yield. Representative Niska.
Thank you, Mr. Speaker. Representative Lugar-Nicolai, will this bill change anything about the legal rights of any disabled person in Minnesota and the process that needs to be followed with respect to their exercise of their legal rights?
Representative Lugar-Nicolai.
Mr. Speaker, thank you. Representative Niska, thank you for the question. The answer is that it will change the practice of the Minnesota Department of Human Rights. These laws already confer an obligation on our employers, our public institutions, our schools, to make access available to individuals with disabilities. The interactive process is spelled out specifically in 363A.08, which is the employment section. It is not referenced specifically elsewhere. However, how you determine whether or not a decision to accommodate or what the accommodation is sometimes something that we work back from in assessing the process by which you reached that. So if someone dug their heels in and refused to do something, and there was no real discussion, and impasse seemed to occur very early on, that would potentially demonstrate a lack of intent to accommodate or to provide a reasonable accommodation. So I think it's important to have the value of the interactive process referenced in our public policy section, because that provides a lens for the Department of Human Rights to assess how a process went down, whether or not it was indeed sufficiently protective of the rights of the individual who's seeking access to a service, a place of employment, or a school. Hope that helps.
Representative Niska.
Thank you, Mr. Speaker, and Representative Lugar-Nicolai. It actually makes it more confusing, because I don't see anywhere in the Minnesota Human Rights Act that the Minnesota Department of Human Rights is limited from fully enforcing all of the prohibitions within the Minnesota Human Rights Act, and has to be directed to do so by some provision in the public policy section. But I do think Representative Nicolai said this bill actually does nothing, which I think is true, actually. I hope that it's true. I hope that Minnesota courts don't think that we are somehow amending the actual operative provisions of the Minnesota Human Rights Act, which is quite robust. I think that, I think a lot of folks in the disability community have been, frankly, misled by the need for this bill, by some sort of concern that the Minnesota Human Rights Act does not have extremely robust protections for disabled folks, which I support. I would have a hard time if there was someone bringing a bill that would water down in any way the protections of the Minnesota Human Rights Act. But what we're doing here is we're taking a may, we're adding a may in an area where an employment, it already says shall, that the interactive process has to be applied. We're suggesting a process that isn't clarified, that will result in some plaintiffs' lawyers, some creative plaintiffs' lawyers attempting to potentially create law in other areas. Maybe the Minnesota Department of Human Rights will try to create law in other areas. To tell Representative Joy that on his gas station on Highway 10, for example, that he needs to have some additional process that he is currently unaware of about what he's supposed to do with the tens of thousands of people who travel up Highway 10 and happen to go to his gas station. I hope that what we've heard today, which is essentially that this bill does nothing, is in fact true. I worry that what we are doing instead is opening up the door for the judicial branch to step into what should be our role, to define what the terms in 363A.08 through 363A.19 mean in a whole bunch of contexts that we as the legislative branch should be doing. And it is not, in fact, silly games for us in our job to talk about what the words are that we're putting into statutes and what they mean and how they play out in real life. That is, in fact, the job that the people of Minnesota have elected us to do. That is our job as the closest branch of government to the people to make those laws, to answer to the public for those laws. This bill, frankly, just isn't ready. It's either not necessary, doesn't do anything, or it does things that the proponents of it are not fully either aware of or willing to own up to. So members, please vote no.
I recognize a member from Hennepin, Representative Nadeau.
Thank you, Mr. Speaker, and thank you, members. And I wasn't going to stand and talk again, but I hope, I have a lot of respect for everybody in this room, and I hope that Representative Niska's fears are not as bad as I hope that that's not the case. It's interesting when, some of you may know that I do some work with people living with disabilities and employment services. And I'll tell you, you go into some of these businesses and the people that are there that are working, they're making, those employers at Ruan and those other places, they are making those accommodations for people who want to work in community so that they can be out there. And there's intrinsic value. And I've talked about that before, that there's intrinsic value in work. And it's especially important for, some of the people that we live with and we live around. And there are brothers and our sisters and, nieces and nephews. And having a process that's put in place where there's the opportunity for employers to have should there be more guidance? Sure. Maybe there should be more guidance. And maybe that's what the Department of Human Rights will do. Most employers that I know that are employing people with disabilities, they love it. They want them there. They want to provide the opportunity for people to work in those environments. And it's not egregious. And it's incredibly beneficial to the rest of the workforce that are working alongside these folks as well. And so I support this, and I know that people are going to vote their district and vote their hearts, and I think that's great. And like I say, I hope that the fears that we have are not going to be true, and I don't think that, Representative Joy, I don't think you're going to have to change anything because the laws are already fairly clear with the accommodations and the accessibility that you need to provide with your employees now. So, Mr. Speaker and members, thank you.
I recognize the author of the bill, the member from Olmsted, Representative Hicks.
Thank you so much, and thank you everyone for the conversation today. And I do just want to say, I wish that the experience of what Representative Nadeau shared and what others have shared that they've witnessed for Representative Ingen with his friend Josh yesterday, I wish that was the experience of all people with disabilities. I wish it was. But the truth is, it isn't. The truth is, the most complaints that the Department of Human Rights receives is people with disabilities. The truth is that disability doesn't care about how much money you have. It doesn't care about where you live. It doesn't care about anything else. Anyone in this room could have a disability, and we maybe would or wouldn't know, but you could all become people with disabilities today, right? You could have a stroke tonight. You could get cancer tomorrow. Anyone can become a person with a disability. And until you're in that space, until you've experienced what that's like, it might seem like putting a sticker on a gas station pump is a bigger deal than helping the person with a spinal cord injury pump their gas. It might seem like that. But if you have a spinal cord injury and you can't get out and pump your gas, the fact that Representative Joy has a sticker on his gas pump with the phone number to the gas station so you can still put gas in your car feels like you're really being included in your community. It feels like you matter. It means that you count. And in Minnesota, I believe that we do think that people with disabilities count. I do think that Minnesotans want all people to be included in their community. I do think that most people in this room probably have someone they love very, very deeply who has a disability. And I would imagine if you have someone you love very, very deeply who has a disability, you've also heard frustrations from them about how hard it is sometimes to navigate the world and how challenging it can be to just be. And people with disabilities want and deserve to be part of our community. They want and deserve to feel like they matter. And nothing in this bill does some of the scary things that were mentioned. We're not inviting lawsuits. That's not what we're doing. We added the word reasonable. We're inviting people with disabilities to be able to fully participate in public and private spaces in this state. We're not changing the meaning. What we're doing is emphasizing that when a reasonable accommodation is requested, there needs to be a conversation. Just a conversation. But it can be really easy to shut that conversation down before having it because it's inconvenient, because it's hard, because frankly, we're all busy and we have busy lives, and it's easy to ignore our most vulnerable. But it's not right, and it's not what we should do. And what this bill does is make that easier, makes that conversation easier, and ensures that people with disabilities are able to be a part of our communities. If cost is unreasonable, if stickers are unreasonable, then that's a conversation too. We added the word reasonable. No one is trying to create the Wild West of lawyers. What we're trying to create is an inclusive state. What we're trying to say is that reasonable people can have a reasonable conversation about reasonable accommodations. And together, we can create a Minnesota where everyone feels seen and heard and included. I do want to just address one last thing, and that is this obsession with the word process. It is a person-centered, individual, informed process. This legislature could decide to mandate that process, but what do we do if someone's non-speaking and uses a Dynavox to communicate? What do we do if we set out a process that doesn't account for some individual need? Then are we really being person-centered? Are we really abiding by what we think our values are? The whole point of this is to be person-centered. The whole point of this is to ensure that we are centering people with disabilities and that we are creating an inclusive and equitable space. So with that, members, I would like to ask you to vote green. And I'd like you to vote green for your neighbors who have disabilities, and I'd like you to vote green for your kids if you have kids with disabilities. I'd like you to vote green for the folks at your church or your faith community. And I'd like you to vote green for all Minnesotans, because disability can happen any day to anybody without warning. And if it hasn't touched your family yet, if you haven't had someone who's experienced this, if you don't have a child on an IEP, or you haven't had a family member who's had a stroke, then maybe you haven't gotten to experience this yet. But you will. And when you do, you'll know that you contributed to making this state more inclusive. You contributed to making sure that folks with disabilities feel heard, seen, and are protected in the state of Minnesota. Vote green.
Seeing no further discussion, the clerk will take the roll. Members, please vote. The clerk will call the names of the members voting remotely.
Momani Hiltsley.
Momani Hiltsley, aye.
Momani Hiltsley votes aye.
The clerk will close the roll. There being 88 yeas and 42 nays, the bill is passed as amended and its title agreed to.